Hello everyone. Today I want to talk to you about whether you can change from a B1, B2 visa once you enter the US to get a green card. And the short answer is yes. My name is Yalda Hijabi, and I'm an immigration attorney. I practice mostly employment-based immigration and family-based immigration. So let's get started. Let's say you want to come to the US on a B1, B2 visa, otherwise known as a visitor visa, either to visit family or friends or engage in some type of business. You can do that, of course, on this visa, which typically the max that you can get it for is 6 months. But what happens in between that and after that if your intent changes? That happens all the time, and there are ways that the Immigration Service can provide benefits for these particular individuals. So if you're here on a visitor visa, it's really important to show that your intent at the time of entry matches the visitor visa that you received. So, for example, you got a visitor visa to come to the US to visit family and friends, that your intent, in fact, was that, and you did that at the time of entry. But your intent can change. That's human nature. And the Immigration Service is forgiving of that. And the way to do that is, let's say you marry a US citizen, you have an immediate family member, so a child under the age of 21, or a parent petition for your green card, or you receive a job opportunity in the US that will allow you to change your status. But a lot of things to keep in mind if you're changing or adjusting status is timing. So I typically like to wait 90 days until I have my clients adjust their status to a green card if they have an immediate family member petitioning for them, or if they're receiving their green card through marriage to a US citizen. The reason for that is that your intent can't change overnight, right? We have to prove that it took some time for your mind to change about returning home. And 3 months is a reasonable period for that. I know there's been some cases where people have done it, filed the case after 30 days or 60 days. I like to stick to the 90-day rule just to be safe. And let's say you get work in the US and you want to change your status, so not adjust your status, change your status to a work visa. You can do that, but be very careful to prove that you have not engaged in unauthorized work as a B1, B2 visa holder. Really, really important to prove that. So what's unauthorized work? If you're presenting for a presentation at a company, that can be unauthorized work. If you're shadowing someone, you're not getting paid, but you're shadowing someone at work, and it's sort of a gray area whether you've actually worked during the day or not. That's considered unauthorized work. It's a very gray area in the law, but I would just be careful with the type of work that you're engaging in. You can interview, but again, be really careful to not accept any jobs and start working on a visitor visa before getting the approval notice for your non-immigrant work visa. And of course, without filing for any type of immigration benefit to work, you cannot work before that. So these are some things to keep in mind. Immigration fraud is a huge issue, and the last thing we want is for your future immigration benefits to be impacted by bad decisions to engage in some fraudulent immigration benefit. So hope those tips were helpful. Please listen to some of my other videos and videos of my colleagues as well. Thank you.